Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. If you have questions, please type them into the comments section below, and we will be sure to address them. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have David Crump with us to talk about his experience as a referring attorney with the Keenan Law Firm. Now, Dave is heavily involved in the Edge. He's from my neck of the woods up here in Washington State. We have a few excellent, dedicated Edge lawyers up here in the Pacific Northwest, and Dave is one of them. And this is an exciting program that Don Keenan allows us to be a part of. I don't know of any other trial colleges doing this. Maybe they do. I just don't know about it. But to be able to access the head honcho, work with his law firm, and have them bring value to your case is just incredible. I've been one, so we'll talk a little bit about my experience. Dave has been multiple times, and so I'm excited to hear about this. And we'll put Dave's contact information in the description box below so that if you have more questions about being a referring attorney, I emailed him before I became the most recent referring attorney. And if you have questions about it, he is kind and generous and will give you the information that you need. So, Dave, welcome. Thank you for being here. Let's talk about being a referring attorney.
Yeah, let's. And, I should say we've titled this The Many Benefits of Being an RA with the Keenan Law Firm. But as I was thinking about it, it's really the incalculable benefits of being an RA. And it truly is. And it benefits you in ways that I'm excited to share about, and also excited for the future RAs to experience on their journeys.
Mm-hmm. Yeah, I hope from this people apply. I think it's an overwhelming thing to think about. I know even it is for me, and I've been doing Edge for a long time, and I know Papa Don and everything. And I emailed you and I was like, do I do this? What do you think? I don't know. So let's get into it. I'm going to turn it over to you. If you want to tell a little bit about yourself, you're welcome to do that. But I'm going to let you go because I know you have some points you want to talk about, and then I'll jump in with questions.
Well, sure. Well, I just realized I've been an attorney for 40 years. And I will say that because of the Edge and the Keenan Law Firm and the Keenan Trial Institute, I do not ever want to retire. This has given a shot in the arm. And speaking of shot in the arm, I had both COVID and flu yesterday, so I'm a little bit gamey. But so there's so much to learn. It's opened up my way of thinking and my way of practicing, and the collegiality of it, and all of the resources that are available. And I'll get into that. But I would like to say that I think, right from the very get-go, RA is Edge on steroids, right? With the Keenan Law Firm as your partner. Now, if you're at all involved in the Edge and you've done a college or two, then I think you probably understand some of the fundamental concepts of Edge. But what the RA will do for you is guide you through the entire process of selecting a case, developing a case at every step of the way, and ultimately either settling it for far more than you ever thought it was worth, because isn't that really what we're here to do, or try it and have a great result. So that, in a nutshell, is what the RA program is. But let me break it down into its component parts. It is, like all things, RA is referring attorney. So what you're essentially doing is you're identifying a case and you're presenting it to the Keenan Law Firm. They are, with the use of focus groups, testing it to determine if it's something that they would like to associate with you on, that it would make a difference and move the needle. Understanding, and if you're an edge person, you know the difference between a system failure case and an event case. But in its components, it is an association with the Keenan Law Firm, and they're going to provide you with all of the necessary resources that they have to make your case have its maximum potential. What are those resources? Well, the first thing they're going to do is they're going to have boot camp and some seminars or workshops that aren't available in the colleges. Special courses that they'll also require you to embark on a journey of fulfilling all of the college requirements and even into the master's level and graduate level. That's great. Highly recommended. These resources, which you receive at no cost, in addition to them working with you in video conferences and one-on-ones, you get every single edge resource at no cost. You get every college for free as a referring attorney. Huge savings. I mean, those colleges are $1,500 to $3,000 up. You get the entire library, all of the books, all of the videos. You get access to your referring attorney and team pretty much 24/7. I've never had a situation where Mindy or Greg or Melinda haven't called me back or emailed me back when I've had a question. And often it's, would you like to have a video conference? And all the seminars are also for free. In my time since 2020, much of what I was able to do was on Zoom, so it was a little bit more efficient. Now you may be encouraged to go down to the beach and to the workshops down there and colleges down there. And that's a wonderful thing too, because you get this, in-person thing that you don't get through Zoom. So, and then, as I said, you get this all-important special sauce, which are these things that they're teaching you that aren't available to anyone else. And I can't really go into them, but I can tempt the viewer here.
Absolutely. And one of the things that's the best, I think, is, we go to the colleges and we learn the concepts and we bring cases to the colleges, and the instructors kind of help us think about how those concepts might apply to our case. But then we have to go back to our office and do it ourselves. And, you do it. KLF is not going to associate on every one of your cases, so that you're not going to get them to, be with you, from the beginning to the end on every case. But if you're fortunate enough to have a referring attorney case, you get to see them apply those concepts to your case. And I don't know about all the folks who are out there listening, but for me, I'm a visual learner, and part of that involves the kinetic, doing. And so I'm like, I understand the concept, but can you show me how it works? And this is the best way to do it, is through this RA program, because nobody does it better than Greg and Mindy and those folks up there. And so you can and they don't do it for you. They have you do it. Okay. So folks, don't make no mistake. They're not doing stuff for you. You're doing the work, but it's just that special, oh, well, no, you didn't do it quite right. Go back, do it again. I tried to do a timeline for my med mal case. I'm on draft 7 and we're not there yet. That's okay. We're just going back and forth. So that's just the coolest thing. So while we can't go into what special sauce you learn, that is such a fun option, or fun part, I think, of the referring attorney opportunity.
Well, that's right. And, once you've been through a referring attorney program, and you've learned how to put your case together, and one of the things that they tell you right off the bat is you have to follow their master case checklist, right? And the master case checklist is a systematic way of developing your case before trial, into discovery, and at trial. Once you do that and you buy into this, you'll never do it a different way again.
Right. And you get to use that, right, Dave, on your other cases? You can.
Yeah. You may have one RA case, but all the rest of your cases aren't. But I guarantee you, when you see how how this works, as I have, you can't but not continue to do this system on all of your other cases. Now, that's time consuming, it's extra work, but it pays off, which gets to something that Don always talks about. It's not necessarily what we need to talk about today, but to have a more select list of cases in your inventory, right?
Reduce your caseload, everybody. I know you're all like rolling your eyes right now, because if we're not talking about reducing caseload, we're talking about focus grouping. So it's one of two things: reduce your caseload and do lots of focus groups, people. It's just so important.
Well, that's right. And you learn, you talked about focus groups, you learn how to do that because when you submit a case to the Keenan Law Firm, you'll reach out to somebody there and they will ask you to provide a written narrative, a brief written narrative of your case. The key here is, but you must highlight the system failure because those are the cases that they want. And when you highlight the system failure in your brief narrative, that lets Mindy and Greg and Melinda focus group it and test it for how much liability is being accepted by your focus group participants, and what is their emotional value, and what do they think about the case, what are their reasons, and then you'll get back from them either, hey, our focus group really liked the case and we'd like to have you come on, and or sorry, this one doesn't work for us, but please keep trying. And I highly encourage you to please keep trying. And here's something, Jenna, that I think is really important. I've talked to newer Edge people about the RA program, and they say, well, I don't have any cases that are worth putting into the Edge. And I can't speak for the value, but I think in tractor trailer and premises, they're looking for cases that have a value of about at least $1 million.
Yep.
And in med mal, at least $5 million. Now, what I've learned is many newer Edge attorneys are not valuing their cases as if they were valuing them like an Edge trained lawyer should. So what I can tell you, my first experience with a tractor trailer case was a case where with the damages, I would have probably settled that for around $600,000. We ended up in the RA case getting about 2.8 million, right? That's a significant change. So you'll learn to value your case higher than you've ever thought, or what you think even the verdict results in your state are showing, because those aren't Edge lawyer verdicts.
Yes. Yeah, that's key. And I mean, I can even testify to that because, Dave, as you know, when I reached out to you about the one that I currently have accepted at the Med, which I still can't believe, I did not think it was worth, I mean, it's a cosmetic surgery. It's a botched cosmetic surgery job or case. And I thought, I took a chance asking Greg just what his thoughts were on the case liability wise. And he was like, let's focus group it and see if it, if it makes sense. And Dave, to his credit, when I emailed him about it, he's like, he saw it right from that system failure Edge perspective. And he was like, you got to talk to Greg about it. You should do it. So yeah. And a point, Dave, that you're making about the focus group thing and continuing to try to submit cases. So KLF does not turn down, like they don't make the decision about turning down a case. And it's really the focus groups. So they will take any case in to focus group it, and then the community will decide whether or not your case meets kind of that value threshold. And the value threshold is not, the focus group doesn't say, oh, this case is worth X dollars. It's that emotional value, right? The emotional scale 1 to 10, how angry are you about this? And so KLF, as we all should, makes their determinations about taking cases based on focus groups. So that's a cool thing, because I've submitted several cases to them that have been turned down. And it's not because KLF is like, oh, the facts are bad or blah, blah, blah. It's because the focus group was like, we just don't care. And but you got nothing to work with if that's what the community thinks, right?
That's right. And, to that point, I've heard of folks who have presented a case to the RA program that was initially declined, but as the case developed and the emotional value developed, Keenan Law Firm saw it a little differently, or the focus groups saw it a little differently. And so even then, don't be discouraged. So, there's some other benefits too that are even a little bit more existential. I mean, obviously, there's this great benefit to you as the lawyer to learn this system that I'm here to tell you, and and many people do, absolutely works. And having done other systems or other programs where there isn't such a system, I can tell you I flailed for many years trying to find a way to make those teachings work. This does right from the get-go. And it's tested over and over again by Dawn, and it's constantly being updated. But you get the benefit of the training, which bleeds over into all of your other cases and your collaborations with your colleagues and friends. Obviously, it makes you more successful. It makes, life in that way better. Obviously, it benefits the client. I mean, aren't we ultimately, we're looking for what is a meaningful result for our client? And there's nothing better than getting your client real justice and the client feeling heard and empowered. And, one of the things we know from client deposition prep is how we empower them. Well, when you do everything right in the EDGE system and you end up getting that client handed off at the end with their check and check in with them over time, you see how the client has not been underestimated. They see us as, they know the difference between somebody that gave everything to change their life and somebody who didn't. But there's one other sort of existential benefit to this, is that particularly with system failure cases, we are, without a doubt, benefiting society because we're shining a bright light on those areas, one case at a time, where a system is broken and needs to be fixed, right? So we're making society safer. And I don't know about you, Jenna, or the rest of the viewers, but when I tell my story now, people ask me what I do. I tell them that I'm out there trying to find safety system failures and improve our society and make it a safer place. It just helps me tell my story better.
Absolutely. Yeah, I've changed the way I talk about it too. And I mean, I was raised in a family who very much did not like personal injury lawyers. Both my parents are in the medical field. Actually, all of my extended family pretty much is in the medical field. So you know how those folks think about us. And it was always embarrassing. People would be like, what do you do for a living? And I'm like, personal injury lawyer, or like, I'd say lawyer. And I'm like, well, what kind? And I'm like, oh God. And they're like, oh yeah, ambulance chaser, ha ha ha. And I'm like, oh man. Well, I don't really feel that way anymore. It's nice to be able to describe, because most people will understand when we talk about what we do and why we do it and the reasons for bringing lawsuits, they'll be on board with it. They just don't always get that education from most plaintiff lawyers. Right.
That's right. So let's say that Keenan Law Firm has accepted your case. They've said, hey, we think that the focus groups like the case, and we'd like to come on board. So what happens next is they will send you a fee agreement. This is an actual association with the Keenan firm, which, by the way, while you get all the benefits of the Keenan firm, you also get all the benefits of the Keenan Trial Institute and all of the listservs, and essentially one of the largest, if not the largest, law firm association in the country of people who want to help, people who know that this stuff works. And you see it time and time again. You hear the stories. One of the things that's fun in the RA program is you will watch your colleagues' cases develop as you watch your own case develop. And then, after a year or two, when those cases mature and begin to settle or begin to get tried, and you hear the stories of how they overcame against great odds for huge verdicts. And there are some amazing stories. And I have seen the lawyers who are telling these stories about their RA cases break down emotionally when they tell them, because they feel so empowered to have done this for their clients, So it does that. But you'll sign an association agreement, and I guess it's okay to say that what they are seeking, or what you must agree to, is 1/3 of whatever your fee is. I believe that's what it is. So
I think that's right. Yeah.
Right. So, which is entirely reasonable. Whether your fee is 1/3 or 40%, they would then get 1/3 of that. Now, almost all of my cases, I'm already associated with another colleague. So, that means less that comes to me, but it doesn't really matter because my mindset is what's best for the client.
True. And also you're increasing the value of your case. There's not going to be a time where you walk into this agreement or this relationship and they're going to make it worth less than you would have been able to do on your own, or, the same amount, or adding value. So realistically, even though you do end up sharing some of those funds, you probably end up with more in your pocket, in your firm's pocket, than you would have before. And certainly the client will. So that's really exciting.
Without question, more in your pocket, and really more bullets in your bandolier, for the next time and all the other cases that you have. And it just builds on itself like a pyramid, and except the pyramid never ends at the top because we're always growing, But I think you'll also find that you will find some cases that you might not have thought had great value, such as you did, Jenna, where you've got this plastic surgery case, and we all sort of, who do med mal stay away from those. But your case had certain triggers and buttons that, made it very attractive, I think, to Bubba Focus Group and Bubba Juror.
Yeah. And that's the other thing is, like, I don't know very many attorneys in Washington or other places who would have even taken this case on. I did it because of my, edge training. And I was like, I think I see a problem here and whatever. I didn't know quite how good of a case it had the potential to be, but I credit the fact that I even brought it into the firm to Dawn's teachings and knowing how to look at something like that and see, I don't know, this is kind of a bigger problem than just what my client is going through, right? Looking at it from that system failure perspective. So your brain is going to be changing kind of through this whole process, not only through the colleges and whatnot, but as an RA, so that you can look at other cases and bring in the good ones and bring in ones that maybe a few other lawyers have passed over. And then cha-ching, you get to, bring in the dough or make it rain or whatever the kids are saying these days for your class.
Well, that's absolutely right. And I have to say that when you talked about your case, I was secretly hoping that KLF would decline you and we could work together on it.
Dave's waiting in the wings like, I know this is a good one. This is a good one. So, well, we'll see. We'll see when it ultimately resolves. Maybe I'll do a breakdown. I did that on a frustrating result I had a couple years ago. I did a podcast, just me kind of doing a debrief. So we'll see. Maybe I'll do a super success podcast for everyone. So stay tuned.
Yeah, right. And every year these various groups, and let me say that you're generally in the RA groups, I believe you've got tractor trailer cases, which, are all your auto type cases. You've got your premises group. Mindy does tractor trailer and premises. You've got your med mal group that's run mostly by Greg. I believe there's an employment group. I don't know. I don't know who teaches that. I think
Mindy does that one. So I think Mindy.
Yeah, and then
Mindy's got her plate full.
There is or was a nursing home group. I think that David may run that. And then I just heard that they're looking into maybe starting a mold group as well.
Oh,
Yeah.
well, I got to tell Young G about that because she's interested in the mold stuff. So
yeah,
cool.
I think there was just recently a little meeting about that Mindy had some folks talking to her about. So, again, you've got all these different kinds of cases. I am not sure, but they may even have a select civil rights group too. Don't know,
Yeah.
Any good system failure case probably is one that they would consider very carefully, as in your favor. All right. One of the other things that they do require in the fee agreement is that your client signed their fee agreement that says they are a member of this team. So you do have to go to the client who may, depending on their circumstances, struggle with this idea of why is some new lawyer coming on? What's wrong here? Are you not up to the task? And, frankly, we all know that clients, we struggle sometimes with, what they're going through and how best to talk to them about that. So, but that is something, and I suppose the Keenan folks can help you with those dialogues as well.
How have you done it in the past, Dave? Because that was actually one of the questions I wanted to ask you. How do you have that conversation? It's a little bit of an ego thing, or it is for me sometimes, or I'm afraid that my client might think, oh, you need somebody to come in and help you. And that's not it at all. I want to do this for them. Sorry about that. Dog's going.
You got a dog?
Yeah, she's on guard duty. So
yeah.
But yeah, I mean, so how do you have that conversation? How have you in the past, Dave, with your clients?
Directly and honestly. Hopefully, I've developed a good relationship and a trusting relationship with the client to that point. And it's like, hey, I'm involved in this program. I think it makes me a better lawyer. This is something that they have available. I think this could only benefit us and you, the client. There can sometimes be the need to continue the case, which, clients struggle with. I think maybe the biggest struggle that all clients have is the time from initiation to closure. And I explained that generally speaking, while there may be this period of time, we can get through it. And ultimately, it will win the war. And if the client is really struggling or doesn't want to do it, then I think we have to honor them. And that's okay, right?
Yeah. Has that ever happened to you?
I haven't had a situation where the client turned it down. However, I have a story to tell about a premises RA case.
Okay.
We had a system failure case in Colorado that happened at a hotel. Slip and fall, trip and fall, woman pretty significantly injured. So the premises group accepted the case, or the focus groups thought it was good. We thought it was a good case. We worked on it. But there were always some funny issues with the client. Now, I wasn't the primary handler of the client, but nevertheless, that's not the issue. What happened was about 8 weeks before the discovery cutoff, our client told us, I am not allowing you to file this case.
Oh, okay. So they didn't want to litigate. They were like, sorry, wait a minute. They didn't, hold on. Let me make sure I understand. They didn't want you to file?
That's right. We were in a sort of pre-filing discovery phase. Everything together. And the client said, and this client has all along had some, whatever it is, some people get a little bit more into, they do their own research and constantly questioning.
Yeah.
This particular client gave the order, do not file this case. So with 8 weeks to go, I called Mindy and we talked to Mindy, and Mindy said, well, not a whole lot you can do but go up to the insurance company with the beggar's cup. Well, because I had been through the RA program in tractor trailer, I had received the one-on-one end game training, mediation and end game training with Mindy and Dawn in person, which is a paradigmatic shift in the way you look at settling your cases, resolving
Interesting.
cases.
I haven't had that yet, so interesting.
The mediation and the advanced mediation cases and the end game are, and I would love to talk offline with you about some of that, Jenna, it really empowers the plaintiff's lawyer, helps us look at the POV of the various parties, the mediator, the defense attorney, the carrier rep, et cetera. So with 8 weeks to go, we nevertheless created a full-on mediation presentation, everything we had. We knew what was going to come out of trial. There were no surprises here. Fortunately, because we had followed the master case checklist, we had all of our ducks in a row, as you're supposed to do pre-filing. I was able to, and my colleague was able to assemble everything and provide the insurance company with an extremely professional mediation presentation and mediation brief. They didn't agree to mediate, but we gave it to them as a settlement demand.
Oh, okay. Interesting.
And with the idea being is we are thoroughly prepared. And I will say that what the mediation programs will do is show the mediator and the other side that you are a top-tier lawyer. And believe me, they see far fewer top-tier lawyer presentations than the other kind, and it's recognized. We ended up, and really right before the day that the SOL was to expire, posturing, saying, "Listen, we're going to file." And this is all the stuff that we're going to, I mean, we had, believe me, they thought that we were going to file for sure.
Yeah.
And it ended up settling for far more than I think, let's just say that it was very close to a magic number and much more than I think any of us anticipated we would have been able to get. Because we had been so prepared and knew what it was we needed to do. We knew how to prepare our visual mechanisms of injury, right? We had all of our experts, which is another benefit of somebody, they will share that with you.
Oh, that's great.
We had the right experts, we had the right reports, and walked away from what could have been certain disaster for many people with a fairly good result.
Awesome. Yeah, that's awesome. I mean, it means so much to have them in your corner when that happens, to say, oh my gosh, what do we do? And it's like, all right, we're not going to just give up. We're going to put it together.
Back.
Yep, woodpecker it away, and make it as much as while honoring, right? Everybody, I hope that you heard that Dave and the whole team honored what the client told them to do. They never once, filed and hoped the client wouldn't notice and it wouldn't go into further discovery or anything like that. They honored what the client said to do, but maximized. Was the client happy, Dave? How did they respond?
I was pleased at the end with it. Yeah. Obviously, there was a little kind of a strange feeling between me and the client on that. Again, I wasn't the primary contact, so tended to have less communication with the client. But yes, the client was happy and was very happy. For some reason, they were just very private people.
Yeah.
And, Mindy had even said, look, you could file under a Jane Doe. I'd never heard of that before.
I don't know if we can do that in Washington. I feel like I've tried that with my rape victims and nobody gives two craps about it. They're like, too bad your name's out,
Yeah. Now, keep in mind, Mindy wasn't just available to us. Mindy was available to us when she was somewhere on an island in the South Pacific, sent an email. She goes, do you need Do you need to have a video conference? Would you like to have a phone call? And so, even then, somebody with real understanding of how these cases work is there to help us at every step of the way.
Yeah, that's awesome. Very cool.
So, there you have it. Now, the other cases, which you're in the MedMal group, and I'm fortunate to have actually 2 cases in the MedMal group because I associated with one of our members on it.
Oh, okay.
Just very recently.
Okay.
I think it's a little different because MedMal cases have, I think, some very different dynamics that we don't often face in the other kinds of cases. We're dealing with, the whole healthcare system and all of the codes that attach to healthcare and people's experiences and expectations about healthcare. I will say this: I don't think I could win a MedMal case today without all of the edge training that is available in the RA. I just think that the vast majority of MedMal cases are going to unfortunately be lost by well-meaning plaintiffs' lawyers.
Yeah, they're tough.
Yeah, and let me say this about the MedMal group, and I think this is true of the other groups as well. I'm sure most of our viewers, your viewers, know about the Inner Circle of Advocates. It's 100 extremely successful plaintiffs' lawyers. I know of at least 2 Inner Circle members who are in the Medical Malpractice RA group. What does that say about the value of what that's providing?
Yeah, they're already the top, and yet they're coming to Don for, his system and assistance with implementing that system within their cases. So
that's right.
Yeah, it's pretty incredible.
I think one of the other great values of this is having gone through it. And it is, as you know, with your multiple versions of your timeline, that is inefficient as hell to figure out how to put these cases together. But, and that's the learning curve. But I'm here to say that every single case benefits from the efficiency. When I get a new case in, I'm wringing my hands with glee because I now know what I can do to expedite the preparation of it.
Yes. Yeah. And I feel like too, one thing I've done more, and I don't want you to think that I missed your comment because I see it. It's coming. We're going to talk about it. But I feel like I do a lot more front loading on my cases. Like I ideally bring in cases before they are close to the deadline of needing to file anything. And hopefully it's not in suit yet and things like that. And I do a lot of work beforehand, like timelines or like talking to experts or whatever, because once you get into litigation, everything is very stressful enough as it is without you also trying to put your case together, kind of like in the middle of it all. So, and that's something that the Keenan Law Firm will take your case at various stages, right? Again, it's all about the focus groups, but ideally, if you can bring it to them before you file, it's pretty great to watch the, system unfold like that.
It is. It's really the opportunity to see alchemy, if I can be, if I can be a little woo-woo in my comment here. But these things, they develop, and it's amazing to see how the work that you're doing and the things that you're doing that they teach you to do, how it changes the complexion of the case. I'll give you an example. Nothing is probably more important to the direction of a case than how well your first depositions of the defendants go. And we can take the hit list college and the deposition college, and we learn a lot. But until you are preparing for those essential depositions and putting together your hit lists, along with all of the codes and those things that are important, with the guidance of your RA mentor, training you as to why this is important, why this may not be important, what is, with the overriding goal being once you've taken that deposition and the first deposition, the case is over.
Mm-hmm.
You may not know it, but the case is over.
Yeah.
And that is a huge benefit because, it's too easy to lose a case by taking a deposition the wrong way.
Yeah, definitely. And as we all know, as folks who are watching out there have heard me say in the past, we don't take depositions to just like figure out what's going on over there. You go in with a purpose and you achieve a goal. And the Edge teaches you how to do that. And the RA program, you get to watch it in action. Well, you get to watch yourself doing it, but they help you.
They help you. And, not all RA cases have depositions taken the same way. In my tractor trailer case, my depositions were more about corralling, grabbing that bull by the horns, dragging it into the yard and closing the gate. And we know that can be a sort of aggressive. In the med mal context, it was actually quite different. As you know, it was about giving the witness some more freedom and latitude to possibly, say something that might hang themselves.
Yeah.
That's all I'll say on that.
Yeah. I'm excited to learn. I mean, I like med mal because I like the medicine, and med mal cases are not about the medicine. And so I kind of got into doing these because I enjoy the medicine, but I'm excited I don't do a lot of them. I've only settled one in my practice. I'm excited to kind of have a clean slate and work through this with you, Dave, and everybody in the group and Greg. So a lot of this stuff is as new to me as it might be to folks listening in.
Yeah. One other thing I wanted to go back and talk about as far as the requirements of the firm becoming an associating with you is they have a full-time illustrator, Blake. And Blake understands, not only is he a very talented graphic artist, he understands through all the cases he's worked with the Keenan Law Firm on how to prepare a visual mechanism of the event, mechanism of injury in a way that they know is most likely to work with Bubba. And of course, it's focus group tested. So they prefer, and it may be a requirement, that when you do your visuals, Blake be the person that does that for you. And there's a $2,500 fee that you need to pay to the firm or to Blake in advance. So, which they just bill, his fee is very reasonable per hour.
I mean, considering how much it costs, I mean, I've spent $15,000, $20,000. I know some people have gotten into the six figures with illustrators. So that's pretty freaking reasonable.
Well, and then, that's a mixed bag. You never quite know who you're going to get or what you're going to get. And the nice thing, not only, as I said, is Blake a great illustrator, in a way that keeps it so simple, right? And that's kind of the key to this whole thing is keep it simple, stupid. But he understands what these things need to look like, what's worked in the past, what's likely to work in the future, and then can change things as the focus groups need them to. So that I think is sort of the last thing that you'll find in your agreement with them, and then they will continue to do focus groups. Now, I like to do a lot of focus groups too, so I will continue to do mine as the firm does theirs on the case, and they do have a small fee for running a focus group on your case, which just comes out of costs at the end.
Yeah. So just so folks know, there will be additional costs, but as I understand it, it's outlined pretty well in the agreement. We haven't signed yet, but I think it used to be a little bit more confusing where it was just the fee split. And then I know at least for our firm, there was a couple of costs that we weren't prepared for. Thankfully, our client was okay with absorbing those. So those would come out of your client's pocket realistically at the end of the day, not if you don't win, but obviously as cost from the settlement, whereas of course fees your client has no responsibility for additional fees above and beyond, which is another thing to talk about. I know this is kind of circling back, but if your client is worried about bringing on another law firm or something, I mean, it's at no cost aside from some of the normal case costs that you'd be paying anyways.
Right.
to you, right? It doesn't, you're not paying two lawyers. You're getting a free lawyer. I'm paying them.
You're getting a free law firm with proven results, and
yeah. So folks, just so you know, and all of this stuff is very transparent. Like when you look, when you sign up and everything, they'll talk to you about it as far as all the financial stuff. But the one thing that's kind of cool, though, before we move off the financial thing is, well, it's not really financial related, but is that they're not entering a notice of appearance. And correct me if I'm wrong, Dave, if they do that ever anymore. I thought maybe they used to at one point, but so they're helping you, but you were the one who's doing it, and you're building your reputation, right, with the ammunition and assistance of another firm behind you. So it's not like defense counsel is like, oh, they're bringing in this other firm to help them out. And so, whatever they might think about that. I know when I was younger, it certainly was an ego thing for me not to have a more experienced lawyer come in and steal the case from me. And so that's a really cool thing. You get to develop your edge reputation in your community, develop that relationship with defense counsel, with the adjuster, whatever it may be, and, with all of the experts behind you.
That's right. That's absolutely right. And, if there was one thing that I wished I had done more when I was a younger lawyer was reach out to more experienced lawyers more often, and rather than think that I could do it, because I think that, and especially had there been edge back in the day, I wouldn't have hesitated to do it. So yeah, you get that. They're in the background. I believe, though, Jenna, that if the case has a high enough value, they will agree to try the case.
I believe you're right. Yeah. It's something like that, where there's like a threshold where they will come in, right?
That's right. That's right. It's, I think, a pretty significant threshold to make it worth everybody's while. But you're absolutely right about it's your reputation. And, one of the things in my tractor trailer case, when we mediated it, I asked Mindy, I said, can we tell them that we have got the Keenan Law Firm, associated? And she says, no, absolutely not. Yeah. But I'll tell you, when we were mediating, I was on the phone with Mindy after every phone move. Mm-hmm. And we didn't know what direction to go. And she had us do some things that were difficult to do.
Mm-hmm. Mm-hmm. Yes.
And she was talking to Dawn. Can you imagine? So you've got all of that resource helping you all along the way.
Mm-hmm. Yeah, it's pretty spectacular.
One other thing, Jen, if I've got a minute, is with the master case checklist and the quarterly workshops, various video conferences and that, they will keep you working on your case, right? Mm-hmm. And some of us have a tendency when we're don't understand something or aren't sure about something to kind of put it to the side.
Oh, yeah.
And it's an impetus to want to show them how good of lawyers we can be.
Yeah, it is. It's totally motivating. I mean, I'm a procrastinator, it's more out of like fear, like if I do it wrong or whatever, and then I just don't want to do it, or if I'm like, I don't know. So this, though, you kind of like want to prove yourself. You're like, I can do this. And actually with my timelines, Greg had to be like, stop sending me drafts because you have to sit and marinate on this and take some time and think about it. Because he's like, this is what I want you to fix. And I'm like, okay, fixed. What do I do next? And they, they'll really kind of help you with those traits that, I think they translate into other cases, and, so when you get nervous about something and you're afraid, you try to put it off, you kind of have that motivation, especially if you're running any cases parallel to what you're doing with KLF. It's just such absolutely, though. I know exactly what you mean, Dave.
Yeah. All that said, this is not the easy way out. Mm-mm. This is work. Mm-hmm. But boy, when it proves itself, which it has never failed to for me. Mm-hmm. It's never failed to. One time I got a result that I wasn't real happy about in trial, but the explanation turned out to be that the case didn't have enough emotional value and the jury wasn't going to fight for me. Mm-hmm. I wouldn't have known that if I hadn't been in an RA group. just sharing that.
Yeah, absolutely. And then Ken, I told you I'd get to your point, Dave. It sounds like Ken Bland, and he said that, as you know, Dave, the RA case I currently have is one I'd initially turned down. The turning point was the 2022 MedMal seminar where the specific issue was addressed. So this is a little bit of a circle back, but we talked about that earlier. Don't, be the woodpecker, even with KLF. If sometimes when we present something to a focus group, it may be that we just didn't have the right information, or we just didn't know how to present it to KLF such that they could present it well to the focus group. So yeah, keep trying.
Keep trying. And, with your timeline and your system failure, you get to keep tinkering with it until you find a way that this gets the 100% convictions and the 10s on your emotional value time and time again. And you take it from there. And Ken, thanks. I hope, glad to hear that you're safe from the hurricanes too, my friend.
Yeah, absolutely. Yeah. Okay, so a couple things. Do you have anything you want? I want to run through a little bit of just logistics kind of stuff before we
go ahead.
wrap.
I think we've covered it.
Okay, so how do you apply? Like, what do you do? Send an email, fill out a form?
Send an email to Mindy if you're in any group other than MedMal, or an email to Greg if you're in the MedMal group. If you don't have their emails, reach out to William, I guess.
Yeah, William is good. Trying to think. Mindy is mbish at KeenanLawFirm.com and gluther@KeenanLawFirm.com. So, those are the folks you want to reach out to. What should I include in that email if I'm applying, Dave?
Yeah, tell them that I've got this case, and would they be interested in it? They will write back and say, give us a narrative, brief narrative. Hopefully, at this point, you have focus grouped it and maybe even have a little PowerPoint. But if you haven't got there, a narrative that, again, highlights the system failure, highlights the defendant's bad behavior. Because what is the first major truth of the edge? Bubba doesn't care about anything but about us, our case, or our client. So they need to have the system failure so that they can test that with a focus group. If you have some kind of an MOE or MOI or something, that's helpful. And they'll test it and get back to you. And what they're testing for is, does the focus group find that there was a system failure that was violated? And how high is their emotional value on this case? And they are looking for 7s, at least, preferably 8s or above.
Yeah. All right, cool. Do you have to be a graduate of the colleges, KTI Graduate?
I believe you would be best served if you've taken rules and case selection. What they will require that you do as part of the agreement is you go through all of the colleges, at least at the undergraduate level. So as you're going through the RA, you're also attending the colleges, starting with, rules and case selection and moving on up to, I guess, everything they offer. And again, folks, that is free. And you just can't, some people take these colleges multiple times, and you can do that as an RA.
Yes.
And the graduate courses are available. I think you can get at least one graduate course for free each year you're being an RA.
Okay. Yeah, I mean, that's an incredible value right there.
If you need to get out of the wintry climate that you're living in, there's generally going to be visits down to the beach if you can make those.
Okay. Well, that's my next question. What are some of the obligations we have, aside from obviously doing the work, kind of participating, additional meetings and whatnot?
Right. I mean, you're expected to show up when there's a video meeting called, or generally, like I said, they have those in-person workshops for the group, which are important to attend. You're down there. Don is down there, so you're getting, not just, but, and each time you go down there, there's a specific focus of what they're trying to teach and work on, So it may be codes, it may be watching focus groups and learning how to see what codes are firing. It could be hit lists, or deposition prep, all of that stuff.
Okay. All right. So attending some additional things. Let's see. Well, we talked about how to talk to your clients about it. So that would be another part of logistics, but that's kind of, you can ask for assistance with that. But, again, part of what the Edge emphasizes so much is having a really good relationship with your client. And, hopefully you visited them in their homes. And I haven't visited my client yet in her home on my med mal case. And I'm just throwing that out there because I know that it can be difficult. Sometimes we have clients in different states or different parts of the state and those sorts of things. None of us is perfect, even those of us who are RAs. But, you should have a good relationship with your client that you can have this conversation with them before kind of moving forward with it. I also wanted to do a little talk on, sorry, not a talk, but what you talked about with your slip and fall case in Colorado, Dave. Sometimes we take for granted that when people come to a litigation attorney, they understand what that entails. Right. And sometimes people that I work with, as coaching or whatever on their cases, I will ask them, what does your client want out of this? And they won't know because we just don't have those simple conversations. Is your client ready if you do file suit? And I'll use my RA med mal case as an example. It's out of Spokane, Dave, as well as one of yours is. And it's a smaller town. It's not a small town, but it's a smaller town, close-knit community. And when you're dealing with medical professionals, in particular plastic surgeons, there are not so many of them. And so I have had multiple conversations with my client about moving forward in litigation because she has her best friend's husband is in business with these people. Her current provider used to work for them. The place that she goes and gets her facials done is everybody's connected. And so you just don't want to the best of your ability, try to have those ongoing conversations. Like when we file suit, it will be public,
Right.
Sometimes the media reaches out, I don't know if you've got some weird small town newspaper that's like, tell me about, why you're suing such and such. So just have those conversations to make sure that you and the client are on that same page. And you
That's
don't get
right. They may not expect that this is what litigation is all about.
Mm-hmm, mm-hmm. They may not know that litigation is a lawsuit either. I know that sounds a little bit weird, but maybe they're like, yeah, I'm all about litigation. And you're like, okay, we're ready to file the lawsuit. And they're like, oh no, I'm not into that. So, have those conversations and early and often. Okay, let's see. Oh, what else did I have in here? Oh, Dave, I don't know if you know the answer to this. Oh, we're technically at the 1 o'clock hour, but there's just so much good stuff here. Give me a couple more minutes, everyone. What if you're in a law firm? Because you own your own. But what if you're in a law firm and you're doing edge stuff? And do you talk to your partners about it? Maybe doing the referring attorney thing. Does KLF help you talk to whoever needs to get permission? Or do you even know how that might work?
Well, I know there are a number of edge lawyers who are in firms, and the firms to varying degrees do or do not buy into edge methods. I can think of, Benji Boscolo's firm, all of their folks, as far as I know, are fully trained in, edge people. But only can speculate that you would probably have to clear it with your partners and give them a good reason why you're doing it. So I can't think of a bad one.
Yeah, it would be interesting. And I'm curious if anyone out there is at a firm and maybe it's not a traditional, like the whole firm, like exactly like Chase and Boscolo, where they're fully inundated in the edge. And yet you kind of wanted the opportunity to work with the Keenan Law Firm. To just tell us how that experience has been, if you've been successful in getting them to allow you to do that and how you did it. Because I was thinking about that. And Dave, you and I are both in a situation where we're not in firms, so we don't have any personal experience to talk about that. I talk to my law partner, but she's usually on the same page with me with that sort of stuff. So,
right. And I think, we have a number of lawyers here, good lawyers in Washington, who have been in the RA programs. And
yes.
Anybody who's done it, reach out. And one other benefit is that, every RA group has its own listserv. Yeah. There's a premises group, a tractor trailer group, a med mal group.
I have yet to be allowed to be, the listservs are wonky for me. So if anybody out there is listening and wants to allow me into the listservs, I feel like I've done enough to warrant being allowed in. So
That would be William.
I don't know. I've sent emails. It doesn't work for me, but all right. We have a shout out here before we close, Dave, from the employment section. The illustrious Ada Wong would like us to give a little shout out to you. Thank you. You're going to be teaching the closing damages college. There we go. Up here in Washington.
Yeah.
So this is, I don't know if it's quite on the website yet, because this was kind of a recent new development. You and Peter are going to be teaching that. It's going to be in person up here in the beautiful Pacific Northwest. So remind me, Dave, what dates they are.
October 18th through 20.
October 18th
and 20, I believe.
Okay, that's coming up. Wow, I better not miss that. Okay.
Did I say October? No, December.
Oh, December. Okay, all right. I was like, oh man, I've actually been signing up for a lot of Edge stuff lately, so I need to.
And the only requirement is you have to have taken closing liability.
Okay, yes, it is. Okay, I'm looking on my calendar. December 18th through the 20th up here in Washington State, and we are on the western side. Probably. It's going to be at Ada's office, which is in Shoreline. So people want to stay in Seattle, you can, or, anywhere around that area.
Yeah.
But yes, thank you. Thank you for doing
more on that.
Yeah. And that's not an RA thing, folks who are listening. This is a graduate college. We've all been waiting so long for the damages portion of the closing college, and it's finally here. So I'm, excited for that, and hope everybody can join us. All right, with that, let's get the outro going. Everyone, thank you so much for being here live with us today. I appreciate everyone who gave us a question. Thank you, Ken, for sharing your story about being a real live RA and having a case that was accepted after it initially wasn't. I'm just thrilled that everyone is still participating in these podcasts. I know that sometimes we have replays and sometimes we have live ones. It is, a work in progress, and it's a fun one. So if you like today's episode, please click that thumbs up to feed the YouTube algorithm. Let the powers that be know that you find our content informational and helpful, that you want to see more of it. We do have another live episode, and I am blinking on when exactly that is, but keep your eyes peeled for the emails, as we are going to continue to have some fun live episodes throughout the fall. And Dave, thank you so much for talking to us about your referring attorney experience. I hope that those of you who are listening will throw your hat in the ring and start trying to get a referring attorney case with the Keenan Law Firm. It will change your life and your practice. Have a wonderful weekend, everyone, and I'll see you next time.